Hello everybody, my name's Andrew Gray, I'm the owner of Truth Legal Solicitors here in Harrogate, and this is I think my second vlog in 6 years, and it's very rare that I want to do a vlog, but our huge opponents, who are a firm called DAC Beechcrofts, are a very capable, competent, large law firm acting predominantly for insurers, defending road traffic accidents. They do lots of other things as well, have posted a judgment in one of their successful cases. They might not always post ones where they've been unsuccessful, but this one is really interesting, and there's a few lessons I think my audience would want to draw from this judgment. So a judgment is effectively what a judge has decided at the end of a trial, and it's usually written down and it reads often beautifully. And this one is all about a learner-driver sort of scenario. And the lessons I want you guys to take from it are about the attitude of judges to claimant lawyers, and some very interesting words that the judge used to describe some people who do what I do, which is act for injured people. Second of all, it's a question about fundamental dishonesty, which is effectively really where a claimant who's bringing a personal injury case has been alleged to have been a bit naughty, been a bit sharp with their how they have pleaded their case, how frank they have been with everybody. Not quite lying, but it's kind of nearly there. And the third thing I want to draw from this is what happens in low-speed accidents. And this one is the definition of a low-speed accident. And it's the case that Beechcrofts have been talking about, which is that of, let me get the name right, Mr. Kazemi, who is the claimant, versus Mrs. Gohill, who was the defendant. And I guess Mrs. Gohill was represented by the Beechcrofts, who are, say, acting for the insurance company in here. So circumstances aren't that interesting, and I think Mr. Kazemi, the claimant, he was a driving instructor, and he had a instructee with him. I think it was Mr. Shah, who I assume was actually driving the car at the time, but I don't know the facts, and it doesn't really matter. And effectively what happened is the learner driver is kind of going through somewhere narrow, I think, and Mrs. Gohill, the defendant, is somewhere perhaps waiting for the car to go by and maybe edged out sooner than they should have done. It doesn't really matter. The blame remained on the defendant's side. So the defendant car, I think, pulled out at a very, very low speed indeed. So the person having the driving instruction, Mr. Shah, doesn't bring a claim, says he wasn't injured, but the driving instructor does. Now in the defendant's car, Mr. Gohill's car, was her granddaughter, and granddaughter, I think, was 2 years old and didn't feel any injury according to information that I have before me. So I want to read to you the key salient parts of the judge's words from the judgment, because I think they are really interesting and very much worthwhile your attention. So the judge said in this case that it was the defendant's fault for the accident. So the claimant was right. The defendant caused this accident where these cars actually scraped against each other, but it was low speed. But the question really, I suppose, for the court was one of what's called causation. Did what the defendant did in moving their car a little bit too quickly, albeit very slowly, and scraping, I think, the claimant's car, was that enough to cause whiplash type injury to the driving instructor? That really was the nub of it, the rub of it. So I'll read the judge's words, and bear with me, but they're great. The judge says, what we are concerned with in this case is causation of the alleged injuries to the claimant. By any stretch of the imagination, this was a very, very low impact accident. The scuff marks I see in the photograph show that there was hardly any movement. This was by no means a rear end shunt. Their car goes into one from the back. Although there is some evidence in the medical papers to suggest that the claimant indicated that there had been a rear end shunt, so the claimant seemed a little confused. It was a passing injury, as the judge said, and we've all had them, whether involved with another vehicle or with a stationary post. I know I've had one with a stationary post, and my wife reminds me of it all the time, and the car was a little bit dented, but I wasn't shaken, I know that much, and it was my fault anyway. Anyway, the judge goes on and says Mr. Shah, I think was the instructee at the time, said that there was no movement to his body, and he was in the same vehicle as the claimant. The judge goes on As for the claimant's allegations of movement, he says, and I made a clear note of it, says the judge, that the actual touching did not cause his body to move, but that he turned to his right to see what had happened, because, of course, the touching of vehicles was behind the driver at the passenger seat of both the claimant and the defendant. The judge goes on. As to the time off claim, so the claimant being away from work, the claimant's evidence was totally and utterly inconsistent. It's all going horribly wrong here for the claimant, isn't it? I do not think that he took any time off. Goes on. Of course, it is true that he was not bringing a claim for time off, and that is probably, judge says, because he could not prove it. At least his solicitor got that right, and that's one of the first sort of jibes, I suppose, at the claimant solicitors in this case. But when we go on to the evidence about pain, again, the claimant was totally inconsistent. Apparently, he told a walk-in centre that he was okay. Then he told a medical expert a month later that it was much, much worse. Judge goes on, you only have to look at paragraph 18, I think of the witness statement, where he says that the injury started a few days later, so it's getting all sort of unravelling here, and compare it with the rest of his evidence, where he said that it came on a few hours afterwards. It is inconsistent, and I do not accept in any measure what the claimant says in this regard. Oh dear. Neither do I think is acceptable in a witness statement sworn at the end of 2016 that the claimant failed to mention that he had had a second accident, on the 25th of July of 2016, which was far more significant an accident. Oh dear. The judge goes on, and he's really, you can see, getting into it. You do not forget that a bus whacked you up the rear end. And if you do not put it in your witness statement, I am going to ask you questions why. Well, of course, the judge would do that, and barristers would as well, no doubt. The judge says, I do not believe the claimant's evidence there. It's getting worse, isn't it? It goes on. The defendant's 2-year-old grandchild was not moved or discombobulated, which has got to be one of the best words ever. Discombobulated. Look that one up. In any way, nor disturbed by this accident. There is no evidence at all that she was, and I find that the impact was far too gentle to cause any injury. I simply do not accept what the claimant says. My judgment is that throughout his evidence, the claimant was dissembling. Love a great word. I think he was, dishonest. Not going well. So the claim for causation was clearly struck out, as in killed and unsuccessful. So what happens here is, although that the claimant was innocent when these two cars there was a sort of scuff on the claimant's car, the judge didn't believe that the injuries could have possibly have come from such an incident. So what happens in these circumstances is that the defendants will say, well, you've put us to all this cost of going all this way, taking it to a trial, and there was no injury. Therefore, we want our costs back for defending this. Now, there's something called qualified one-way cost shifting, the idea being that claimants who lose personal injury claims but do so sort of honestly and having brought the case properly don't have to pay the defendant's costs, right? Unless the claimant is proved to be fundamentally dishonest, which I guess is the finding here. So, as it went on, the judge accepted what's called an application by the defendant at the time for the claimant to pay the defendant's legal costs. So not only did the claimant not win, but he had to pay £8,962 of the defendant's costs. Now, I don't know why he has to do with the claimant's costs. That's not clear from here, and it wouldn't be. But £8,962 for bringing a whiplash claim unsuccessfully. Oh dear. A lesson as well for all people instructing claimant solicitors and who are involved in this road traffic accident sort of world, innocently, you've had an accident and so when you're bringing a case, I think it's really worth scrutinising this final or penultimate paragraph, 2 paragraphs from the judge. And I'm going to read them out, so I'll be looking down, but it's great. The judge says, it must be aware to anyone sitting in these courts that if claimant solicitors spent half as much time as they do spend considering whether it was worth going ahead in these cases, they would save an awful lot of money. It is clear that Mr. I'll say the opponent, defendant's solicitor or litigator is experienced. He rightly, on behalf of a serious insurance company, and I think they're all serious, has spent a serious amount of time considering this case in a way that the claimant solicitor obviously didn't. You don't very rarely see sort of criticism of this type of the claimant solicitors. That is probably because the claimants employ children to do these cases, and this has to stop. I read it again. That is probably because the claimant solicitors employ children to do these cases, and this has to stop. Now, when I saw that yesterday, that was, wow. I've never read, heard, seen criticism of claimant solicitors like that. I don't know who the claimant solicitors are in this case. I don't know the age of the person who was acting for the claimant. I don't know whether they're a qualified solicitor or qualified legal executive. I don't know, but you can see that I think that the judge in this case was beyond miffed with some of the quality of the legal work that claimant solicitors have been doing. The judge goes on, and I think this is an interesting, relevant point as well. I don't expect everyone to get a violin out about claimant solicitors' legal costs, but it is worthy of note. I think people need to know how the sausage is made. The judge said, "It is not my fault that the claimant solicitors are restricted to pathetic costs that they are in this sort of case, where serious, I'll say it again. It's not my fault that the claimant solicitors are restricted to pathetic costs that they are restricted to, and that this is something that someone at some stage will have to take up with the Ministry of Justice, indeed. But it is right that in this sort of case, where serious allegations are made against a claimant individual, that serious people give serious amounts of time to what they are alleging. Here. The allegations of fundamental dishonesty are not made lightly, and it is right that a message goes out that these courts will not put up with it." Fair enough. I think anyone reading the judge's judgment here or listening to my podcast can sympathise with the judge in this case for making that finding, and sympathise with the insurers for contesting such a low speed accident. I sympathise with that position indeed. But also think about it from this sort of the claimant's going through this process. The implication is that the person who's running the case for them probably wasn't qualified, I guess, which isn't, you don't have to be qualified to run those cases. But I guess that's what's happened here. I guess the judge goes on to say the reason, I suppose, why claimant solicitors aren't as competent as I think they were when I first started practicing is down to the pathetic costs, as the judge called it. And it is right, we are, claimant solicitors, paid an awful lot less than we were years ago. I would guess, on average, 1/6 of what the fees were probably, 7 or 8 years ago or so. So I guess with that, the quality of the law provided to people who were innocent victims in injuries and claims like these, I guess that the service has declined. That's been my experience. So why I suppose one of the reasons it was very interesting is, so in my firm, Truth Legal, we deal with a lot of people who are disgruntled with their present solicitors because they don't think that the people acting for them are probably qualified, can put enough time into it. But as you see from the judge's comments here, it is down that the costs aren't as high as they once were. So there is been a bit of a drive for some claimant solicitors to have hundreds of cases with paralegals and have very effective what's called case management systems to process cases as fast as they can, and therefore to be able to make a profit. I mean, of course, if the law firm doesn't make a profit, it will inevitably close. So it's a sad story, useful, I think, for everybody who's going through a personal injury claim to know this when thinking of who to instruct and who not to. If they've got a low speed impact claim, you can see how the insurers have good reasons to want to be able to fight some of these things. And you can see that the judges, in this case, this judge was not at all impressed. I guess it's almost if he's blowing off steam as to previous matters that had come before that court. So there we are. Interesting. Thank you for your time. And if you want to get in touch with us, there'll be, I'm sure, some section on our website on the right or left, or depending on which side you're watching this from. So thank you very much. Bye bye.